Good evening, students. So today we have
Casting creme gloss from
quiz
L'Oreal Paris.
on Criminal Procedure and Indian Evidence Act, right, for MP Judiciary 2023. Uh, so you will be given kind of 10 seconds uh, to write your answers in the chat box or in the comment box when I start. So just give me a minute, students. Yes. So before we can start, can you just confirm if I'm audible and is my screen visible to everyone? Yes, students, can you please confirm if the screen is visible to everyone and if I'm audible also? Yes, students, if someone can please confirm if I'm audible and if my screen is also visible to everyone so that we can start. Yes, I'm getting no comment or no message in the chat box. So if someone can kindly confirm so that we can proceed with the quiz today. Okay, okay. So I was muted. Rajput, can you hear me? Am I audible to you now? Am I audible to everyone now? And is my screen visible to everyone? Please comment in the chat box if I am audible and if my screen is clearly visible to everyone here. Okay. Monica says yes. So, Monica, can you please, Monica and Rajput both are here. Can you just answer the first question? Okay. Please answer the first question. Students, am I not audible? If you don't confirm, how will I know? Please confirm others also. Shaktija, Monica, Ayush, so I'm not audible. Monica, Kansha, Rajput, am I audible to everyone or am I not audible? Now I am audible. Okay. Ayush, am I audible to you also now? Ayush, are you there? Okay. Give answer to question number 3. Am I audible now? Okay, I think I'm audible now. Students, am I audible now? Shaktija, Akansha, am I audible? Okay, got it. Got it where the issue was there. Okay, for question number 3, I have written the option. Option is A. Okay, what is section 33 of Indian Evidence Act? What is section 33 of Indian Evidence Act? Yes. 33 of Indian Evidence Act talks about relevancy of certain evidence for proving in subsequent proceeding the truth of fact therein stated, right? And when the witness is staying abroad, it will not be relevant under 33. Okay, Monica, if you cannot see it clearly, just follow my voice also. Okay, you can follow my voice also. I'll just repeat. I'll just dictate the question also to everyone, so you can follow that. Coming to question number 4, can you tell me the answer to this question? The definition of secondary evidence is given under which section of Indian Evidence Act? Now, this is a very easy question. I don't think I need to tell you all the options also, right? Because this is so easy. Where is secondary evidence defined? Section 61, 62, 63, or 64? Even if I wouldn't have given you the options, I think you should answer this. Akansha says 63. Monica says 62. Okay, what about others? Where is secondary evidence defined? So the correct answer is yes. Very good, everyone. Uh, yes, all those who answered option C for question number 4, that is section 63 is the correct answer. Okay. Section 63 talks about secondary evidence. That means primary evidence is defined in section 62, right? Section 62 is for primary evidence and 63 is for secondary evidence. So all those who gave the answer 63, section 63, that is option C, is correct. Okay, moving on to the next question. Please read the question. According to Section 65 of Indian Evidence Act, secondary evidence can be admitted in dash exceptional cases. How many exceptional cases are there? 3, 5, 7 or 9? How many exceptions are mentioned under Section 65? Is it 3 exception or 5 or 7 or 9? Please tell your answer. For question number 5. Okay, so two answers have come. Okay, three answers have come now. Akansha, Shaktija, and Monica has answered 7. All have answered 7. What about others? What about others? Very good. Everyone who wrote option C are correct is correct. It is option C. Very good, everyone. Option C is the correct answer. To Chavi, the question is not visible. Chavi, if the question is not visible, follow my voice. Okay. Let me see if I can write the question in the chat box also. Okay, coming to question number 6. Which of the following sections of Indian Evidence Act give provisions regarding proof as to electronic signature? Let me see if I can post the question in the chat box also. Okay, I will be posting it here only then. Which of the following sections of Indian Evidence Act 1872 gives provision regarding proof as to electronic signature, right? And the options are section 67, 67A, 67B, and 67C. I'm not writing the options in the chat box, I'm just writing the question. Okay, continue giving your answers. I will only reveal the answer when you have written. So 67A. Everyone is opting for 67A, that is option B. And yes, the correct answer is option B, that is section 67A is the correct answer. Section 67A is the correct answer, that is option B. So everyone who wrote B, give a clap to them. So you all can just pat on your shoulders and others can clap for them who has written for 67A. Now coming to the next question. Which of the following section of Indian Evidence Act has been amended by CR Criminal Law Amendment Act 2013? And the options are section 32, section 655, section 119, and section 124. So the options are 32, 55, 119, and 124. Which section has been amended by Criminal Law Amendment Act 2013. Everyone is. Acha, did I write 119? Acha, 119, right. So this is section 119 which Ati Divya has written. What about others? The correct answer is very good. Everyone who has written the answer as 119, it is correct. So the answer is section 119. Moving on to the next question. Which section of Indian Evidence Act was inserted by Criminal Law Amendment Act 2013? Now, see the difference between the two questions, right? So one section 119 was amended, and here I'm asking the question: which section was inserted by Criminal Law Amendment Act 2013? And these are the option 53, 53A, 119, 119A. So for all those who can, if you are having problem seeing the screen, right, you can, for all those who are having problem seeing the screen, I'm also posting the questions here. Okay, question number 8 is: which section of Indian Evidence Act was inserted by Criminal Law Amendment Act 2013? And Ati Divya says 53A. What about others? What about others? See, the option are 53, 53A, 119 and 119A. Please think and tell me the answer. Write in the chat box. The question is already posted in the chat box. Start giving your answers. No more answers coming. So the correct answer is section 53A. Chavi and Atidivya are correct. Yes, this is the correct answer to question number 8. Now see question number 9. Relevancy of facts forming part of same transaction is dealt under which section? Section 4, section 6, section 10 and section 8. Giving you all 10 seconds to answer this question. Relevancy of facts forming part of same transaction is dealt under which section? Section 6. Section 6. Okay. Anyone else who wants to answer? And yes, the correct answer is section 6. Very good. It is relating to res gestae, right? Section 6 relates to res gestae, and section 6 is the correct answer. Okay. Moving on to our next question. Declaration in course of business are admissible under which section? 32 clause 1, 32 clause 2, 32 clause 4, 32 clause 7. So the declaration in course of business is mentioned under which section? Question has been posted. Please start writing your answers. Very good. Atidivya, Chavi, and Shaktija. The correct answer is 32 clause 2. Good. Okay. Next question. Declaration as to custom is admissible under which section of 32? Clause 1, 32 clause 2, 32 clause 4, 32 clause 7. Declaration as to custom are admissible under which section? Please start writing your answers. Okay, also write your answers only. I have posted the question so that we can understand that you are writing answer to that question only. Right? Declaration as to custom is admissible under which section? 32 clause 1, 32 clause 2, 32 clause 4, 32 clause 7. Yes. What is the correct answer? Very good. All those who have written 32 clause 4, the correct answer is 32 clause 4. Very good. Okay, moving on to next question. Opinion of expert is relevant under which section? Opinion of expert is relevant under which section? 45, 46, 47, or 48? I don't think I even had to I even have to give the options to this question. Okay, you will start posting your answer only when I have posted the question. Okay, just wait. Yes, okay, answers have started coming, which is 45. 45, Shaktija has written 46. And the correct answer is section 45. So Chavi, Atidivya are correct. The correct answer is section 45. Moving on to next question. Under section 45 of Indian Evidence Act, the opinion of expert can be for what? Identity of handwriting, identity of finger impression, for both A and B, for neither A and B. Yes, so answers have started coming. And yes, the correct answer is for both. Option A and B is the correct answer. So those who have written both A and B are correct. Okay, moving on to next question. Under section 45 of Indian Evidence Act, the opinion of expert can be on the question of, and options are Indian law, foreign law, both A and B, only A and not B. Yes. So the correct answer here will be option B, which is foreign law. Option B, foreign law, is the correct answer. Okay, moving on to the next question. Facts of which judicial notice is to be taken are stated in which section of Indian Evidence Act? The options given are 56, 57, 58, or 55. The options are section 56, section 57, section 58, or section 55. Of which judicial notice is to be taken is stated under which section? Yes. So all those who have written section 57, that is the correct answer. Good. Option B, section 57 is the correct answer. Moving on to the next question. Oral evidence under section 60 of Evidence Act may be. Option are direct only, hearsay, both A and B, either A or B. What is the option? Yes, Atidivya says A, that is direct, direct. Mm-hmm. Right. The correct answer is option A, direct only. Next question. The calling of at least one attesting witness to prove a document under section 68 is not necessary, and these are the options which I'll just tell you after posting the question. Please see the question. The calling of at least one attesting witness to prove a document under section 68 is not necessary, and the options are A, when the document other than a will is registered under Indian Registration Act, when the document including will is registered under Indian Registration Act, when the document irrespective of whether it is a will is registered under Indian Registration Act. Both B and C are correct. Let me see if I can post these options also, so that you can just write the option. Just write the option because it is, you know, big options. So I have written it. Yash, please see the question. I have posted it in the chat box also. If the screen is blurred, just look at the option and just look at the question which I have posted, and the options also I have posted. Okay. So for all those who cannot see the screen, I have posted the question and the option to this question on in the chat box. Start answering. The correct answer is option A. I have Mark that in the chat box. The correct answer is option A. Okay. Moving on to the next question. Public documents are mentioned in which section of Indian Evidence Act? 72, 73, 74, 75. Tell me the correct option or the section for this question. Public documents. Very good. The correct option is option C, section 74. Section 74 mentions public document and section 75 mentions private documents. Okay. Now if anyone knows the meaning of this maxim, omnia proesumuntur right esse acta. What is the meaning of this maxim? Omnia prosemuntur right esse acta. All acts are presumed to be rightly done. All acts are presumed to be not rightly done. All acts are presumed to be wrongly done. All acts are presumed to be not wrongly done. Yes, the correct answer is option A. Uh, okay, so just wait, students. Option A is the correct answer that says all acts are presumed to be rightly done. Right? This is the correct meaning of maxim omnia prosemuntur right esse acta. Okay, next question. Presumption as to accuracy of maps and plan made by the authority of government is contained in which section? 81, 82, 83, and 84. Yes. So the correct answer is option C, which is section 83 of Indian Evidence Act, talks about presumption as to accuracy of map and plan. Moving on to the next question. Yes. Facts showing existence of state of mind or of body or bodily feeling is dealt under which section of Indian Evidence Act? The question has been posted. Please start writing your answers. Is it section 12, section 14, 16, and 10? Facts showing existence of state of mind or of body or bodily feeling. Yes, the correct answer is section 14. Very good. What does section 16 say, students? Section 16 talks about which what? It talks about existence of course of business when relevant. And 10 and 12, 10 talks about conspirator wala thing. Things said or done by conspirator. And 12 talks about in suit for damages. Facts tending to enable court to determine amount are relevant. Right? So 14 talks about the existence of state of mind or of body or bodily feeling. Okay, moving on to next question. The question is whether A was robbed. Applying Section 8 of Indian Evidence Act, which of the following facts can be relevant? Right? So the question is that whether A was robbed, and these are the options which I am posting again in the chat box because these are a little big options. So I have just posted it. Please see the options and tell me the correct option. A, B, C, or D. Which one do you think is correct? So many have said Shaktija and Atidivya says D. Option D, all of them. So if you see section 8, right, and the last illustration to section 8, that is illustration K. The question is whether A was robbed. The fact that soon after alleged robbery he made a complaint relating to the offense, right, and the circumstances under which and the terms in which the complaint was made are relevant. The fact that he said he had been robbed without making any complaint is not relevant as conduct under this section, though it may be relevant as a dying declaration under section 32 clause 1 or as a corroborative evidence under section 157, right? So the correct answer to this is option D. Yes, option D is the correct answer. Now let us move on to the next question. Section 162 of CRPC is for protection of whom? So now let us see. Now we are coming to CRPC. Section 162 of CRPC is for protection of whom? Accused, witnesses, police officer, or magistrate. who does who does section 162 protect? What does section 162 talks about? It talks about statement to police not to be signed, use of statements in evidence, right? So the correct answer to section 23 is what? So the correct option is witness only, right? The correct answer is witness. Section 162 protects the witnesses. Coming to 124, an order under which section of CRPC will act as a bar under section 300 of the Code of Trial of the accused for the same offence? An order under which section of the Code of CRPC will act as a bar under section 300 of CRPC to trial of the accused for the same offence? Section 256, 203, 227, 239. Yes, an order under which section will act as a bar under section 300 of the code to the trial of accused for the same offence? Options are 256, 203, 227, and 239. Please start writing your answers. No answer is coming. Atidivya and Chavi has only mentioned 239. What about others? What about others? Yes, if you all read section 300, right? So there is an exhaustive view of this concept, right? Please read 300 and tell me the correct answer. 221 and 220 are not mentioned here, but what I have mentioned is 256, 203, 227, and 239. So I'm moving on to the next question first. Okay, leaving this to you only. You all have to answer this. Come to 20. So I'll come to this question. When the police register a case regarding a commission of a cognizable offence, the registration of the case is under which section of CRPC? When the police register a case regarding commission of a cognizable offence, the registration of the case will be under which section? Start answering. Yes, the correct answer is 154. Right, right, 154. Coming to next question. The investigating police officer in case has power to require attendance of a person acquainted with the facts and circumstances of the case under which section? 158, 159, 160, or 161 of CRPC? The investigating police officer in a case has the power to require attendance of a person who is acquainted with the facts and circumstances of the case under which section? 158, 159, 160, and 161. Start answering. Yes, the correct answer is 160. Good, Chavi. Good. The correct answer is section 160. Students start answering a little fast, okay? Acha, section 160 of CRPC authorizes a police officer to what? Summon a person as witness, summon a person for production of documents, summon a person for production of article, all of the above. What does 160 authorize a police officer to do? Section 160 of CRPC authorizes the police officer to do what? Summon a person as witness, summon a person for production of document, summon a person for production of article, all of the above. Why are you people writing D? Can under 160 can is police officer authorized to summon a person for production of document or production of article? What do you think? Under 160 is the police officer having the power to summon a person for document production or for article production? Yes. Or is it only attendance? Tell me. Right? C160. Is it allowing a police officer to summon someone for production of document or for production of article? Or is only requiring summoning him as witness? Please see section 160. Come to next question. A magistrate of first class may award a sentence of imprisonment up under CRPC up to a period of how many years? Under which section is it applicable? 24, section 28, section 29, or section 41? In all the options, we have given a period of 3 years, but under different sections. So you all mention the correct section. Mention the correct section. Yes, the correct option is C. Period of 3 years under section 29. Right? Period of 3 years under section 29. Why are answers not coming? Only Gaurav has written the answer. What about others? So, under section 29, the magistrate of first class can award a sentence of imprisonment up to a period of 3 years. Okay. Under, yeah, 3 years, but under which section? Under which section? Under section 29, right? Under section 29. That is important to mention. Coming to the next question. Now, this is very easy. Section 27 relates to which? To what? Juvenile jurisdiction, PIL, res judicata, ya none? Section 27 of CRPC relates to what? Juvenile jurisdiction. A is juvenile jurisdiction, B is PIL, C is res judicata, and D is none of the above. Yes, the correct answer is juvenile jurisdiction. Section 27 relates to juvenile jurisdiction. Okay, next question. Which section of CRPC prohibits the male police officer from touching the person of a woman while making her arrest? Which section of CRPC prohibits the male police officer from touching the person of a woman while making her arrest? Section 39 proviso, proviso to section 49, proviso to section 69, proviso to section 46. Start posting your answers fast. Start posting your answers, student. What happened? Start giving your answers. Only Chavi is giving the answer now. Yes, Chavi, right. So the answer is proviso to section 46, right? So if you see the proviso to section 46, you will find that um, it mentions about it prohibits the male of police officer from touching the person of a woman while making her arrest. Acha, irregularities which do not vitiate proceedings are mentioned under which section? Irregularities which do not vitiate proceeding mentioned under which section? I don't think I need to give the option also here. You all can answer. Any answer to this question? Irregularities which do not vitiate proceedings are mentioned under which section? Yes, students. No answer is coming. Such an easy question. Where do you find the irregular proceedings and irregularities which do not vitiate proceeding? Yes, Gaurav has given option A. That is section 460. Gaurav is writing. What about others? Gaurav has then given 461. No, the question is which do not vitiate. Which do not vitiate. Is it 460 or 461 or 462, 486? These are the options. The correct option is option A, section 460, right? Section 460 talks about irregularities which do not vitiate proceedings, and 461 talks about irregularities which vitiate proceedings. So the which do not vitiate is 460. Okay, next question. Court can condemn delay under which section of CRPC? Court can condone delay under which section of CRPC? 470, 471, 472, 473. Tell me. Gaurav is as written 473. What about others? What about others? Yes, the correct answer is section 473. The court will condone delay under 473. Very good, Gaurav. Next question. Addition or alteration of charges provided under which section? Addition or alteration of charge is provided under which section? What about others? Only Gaurav is answering. What about others? Write your answer. Others who are present, please write your answer. Chavi also says 216. Yes, the correct answer is 216. The correct answer is 216 only. Good. Okay, moving on to next question. Now there is a rule autre for acquit or autre for commit is contained under which section? 321, 320, 300 or 3 or 298. Autre for acquit and autre for commit. Gaurav is giving his answers quickly. He's well versed with all these provision. Very good, Gaurav. What about others? This principle autre, it's fois. Okay, it will be fois acquit and autre fois convict. Where is this principle related to? Okay, autre fois acquit and autre fois convict. Any other answers for this section? For this legal maxim, what do you mean by autre fois acquit and autre fois convict? Yes. The correct answer is section 300 only, which Gaurav has given. Very good, Gaurav. Next, cognizable offense is defined under which section? Now I don't need to. Uh, yes, Mr. A has also written. Cognizable offense is defined under which section? Where is cognizable offense defined under? Which section? Very good. 2C. Good. 2C is the correct answer. Acha. Complaint which is provided under section 2D of CRPC can be in writing only or can be oral, either in writing or oral, or can be by gestures. The options are in writing only, oral, either in writing or oral, or can be by gestures. Very good. Yes, either in writing or oral. Very good. Good. Gaurav and Saurav. Next question. Laying of a trap is a part of what? Investigation, inquiry. Laying of trap is a part of investigation, inquiry, preliminary inquiry, or trial. Saurabh, is my voice audible to you now? Laying of trap is a part of investigation, inquiry, preliminary inquiry, or trial. Very good, Gaurav. Yes, the correct answer is investigation. The correct answer is investigation. Laying of trap is a part of investigation. Okay, next question. Section 162 of CRPC prohibits a statement from being used in evidence made in the course of what? Inquiry, investigation, trial, or either inquiry or investigation. What will be the correct answer? Inquiry, investigation, trial, or either inquiry or investigation. Please write your answer to question number 38. Yes, very good. The correct answer here is investigation again. 162 of CRPC will prohibit a statement from being used in evidence made in the course of what? Investigation, or the answers are also coming trial, but the correct answer is investigation. Please see section 162 of CRPC. What does it say? No statement made by any person to a police officer in the course of an investigation. Right? So it prohibits a statement from being used in evidence which has been made in the course of what? Which has been made in the course of investigation. The correct answer to question number 38 is investigation, because if a witness is telling something during investigation, it cannot be used later, right? Coming to next question. Maintenance of a case diary is directory, mandatory, discretionary, or neither mandatory nor discretionary? What do you think? Maintenance of case diary. Maintenance of case diary is what? Directory or mandatory or discretionary, or neither mandatory nor discretionary? What do you think? Please write your answers to question number 39. Gaurav says B, that is mandatory. Yes, the correct answer is mandatory. Maintaining case diary is mandatory. Okay. Maintenance of case diary is mandatory by an investigating officer under which section? 162, 167, 172, or 174? Maintaining case diary by investigating officer is mandatory under which section? Yes, very good. Section 172. Yes, Gaurav. Good. What about others? What about others? Why are you people not answering? Come to this question. Maintenance under section 125 cannot be claimed by a married daughter who has attained majority, or a legitimate or an illegitimate minor child, by father or mother, or all of the above. Tell me the correct option here. Maintenance under section 125 cannot be claimed by. Gaurav says A, married daughter having attained majority. What about others? What about others? Please write your answer. Yes, the correct answer is married daughter having attained majority, she cannot claim maintenance. Next question. Joinder of charges is permissible under which section? Joinder of charges is permissible under which section? 219, 220, 221, or all of the above? 219, 220, 221, or all of the above? Joinder of charges is permissible under which section? Any answer for this? Students, can you answer this? Joinder of charges is permissible under which section? 219, 220, 221, or all of the above? The correct answer here is D, all of the above. It is permissible under 219 also, under section 220 also, under 221 also. Okay. Yes, Saurabh, it was married daughter, right? The second question, Saurabh, which is joinder of charges is permissible under, the correct answer is all of the above. Okay, 219 also, 220 also, and 221 also. Coming to next question, Indian Evidence Act was drafted by, now this cannot be like, I can't think of an easier answer than this. Indian Evidence Act was drafted by whom? Lord Macaulay, Sir James Fitzjames Stephen, Huxley, or Sir Henry Maine? Who drafted Indian Evidence Act? Please write your answers. Indian Evidence Act was drafted by whom? What is the correct option for question number this 43? Indian Evidence Act was drafted by? Please write the correct answer. It was drafted by whom? Yes, Saurabh, right. The correct answer you have mentioned. Now tell me the answer to this question. Indian Evidence Act was drafted by whom? It was drafted by Sir James F. Stephen, right? Sir James F. Stephen is the one who drafted the Indian Constitution. Sir James F. Stephen. Okay, coming to next section question under Evidence Act. Fact means what? Factum probandum, factum probans, both or none? Under Indian Evidence Act, what does fact means? Factum probandum or factum probans? Under Indian Evidence Act, fact means both factum probandum also and factum probans also. So it is both factum probandum and factum probantia. Now, who does Section 27 control? Section 27 controls Section 24, Section 25, Section 26, or all of the above? Please tell me, who does Section 25 control? 24, Section 25, Section 26, or all of the above? Please write your answer. Yes. No answer is coming. What happened, students? Tell me this question ka answer. Dumb person is a competent witness under which section? Saurabh, it will be both. Fact means both. Factum probandum also and factum probantia also. Tell me, dumb person is a competent witness under which section? Dumb person is a competent witness under which section? Yes, yes, Saurabh. Factum probandum is a material fact and factum probantia is the evidence. But Indian Evidence Act, under Indian Evidence Act, I'm talking about the fact which is there. And fact, if you see fact in issue, right, they are those facts which are sought to be proved and they are also called principal facts or factum probandum, right? Facts in issue are those facts which you also see from principal facts or factum probandum, है ना? So if you see the meaning of fact under section 3 of Indian Evidence Act, it means and include anything, any state of things or relation of things capable of being perceived by senses and any mental condition on which any person is conscious, right? So if you see the meaning of fact and the meaning of fact and issue also, so Indian Evidence Act, yes, factum probantia is the evidence, but it is including also anything or any state of thing or any relation of thing, right? So when you see the definition of fact is in, it is including physical fact also and psychological fact also, right? And the relevant fact, if you see, um, also like the connected evidences, if we see, and the Latin phrase is facta probantia there, which we call relevant facts. Yes, sort of there. Indian Evidence Act deals with both. Why, Saurabh? You know now, fact, it deals with fact and issue also. It's also talking about relevant fact. So fact and issue is my factum probandum, and relevant fact is my factum probans. So Evidence Act is dealing with both fact and issue also and relevant fact also. So it is dealing with factum probandum also and factum probans also. Saurabh, clear about this? Yes, Saurabh there. I hope this is clear to you, Saurabh. I have already written Indian Evidence Act is talking about both about facts in issue, also factum probanda, and relevant facts, also factum probans, right? So it is dealing with both. Saurabh, is this clear? That it is dealing with both. My fact in issue is factum probanda, and my relevant fact is factum probans. Now, dumb person is a competent witness under which section? I think I'll. This will be my last question. Dumb person is a competent witness under which section? Okay, dumb person is a competent witness under which section is my last question. Tell me. Dumb person is a competent witness under which section, students? Under section 119 of Indian Evidence Act. Section 119, if you see, of Indian Evidence Act, it talks about dumb witness, right? Right? Section 118 talks about who may testify, and section 119 talks about dumb witness. Right? So with this, I will like to end this quiz session today. Thank you so much for your patience and thank you for your interaction. You people have been really interactive today. I was really happy to see the answers coming in the chat box. I'll like to end the session now. All the best. Okay, Saurabh, I'm ending the session now. Okay, thank you and all the best.